want to thank Senator Blackburn for putting together this hearing, along with Chairman Grassley. This hearing is covering an important topic, lawfare. The lawfare that specifically that occurred under the Biden administration at unprecedented levels. I think every senator in this room ought to be able to recognize that simply being in contact with the President of the United States does not mean that one should be targeted by the U.S. Department of Justice. And I think everyone in this room should be able to recognize the consequences of this sort of action. This is the kind of offense that occurs a little bit like a hit and run, but it's worse. With a hit and run, you don't know who hit you. They ran over you and then left. But at least with a hit and run, you might have somebody, some eyewitness, perhaps the victim, perhaps somebody else who might be able to describe the car. Here, the victim doesn't even know what or whether they've been hit, but they have been injured nonetheless in one way or another. And the non-disclosure order made darn clear of that. And this is the sort of thing that occurred under President Biden's direction. Now, not only were Republican senators targeted in what appears to be the political weaponization of the Department of Justice under Special Counsel Jack Smith, but as we learned during the hearing held previously by Senator Cruz, Judge Boasberg went even further by granting these non-disclosure orders that prevented the targeted senators, myself included, from even learning about these for years. In fact, it's only been in recent days that I discovered that I was among them. It was only through Chairman Grassley's oversight, his dogged determination to look into this, that these actions came to light. Otherwise, we may never have known. Now, look, this should not be a partisan issue because these doors, once they start swinging, they swing both ways. The Department of Justice must never be weaponized against members of the opposing party. It shouldn't happen. And here it was triggered by the fact that they had communicated with the President of the United States, something that all of us do on some regular occasions, on many regular occasions. Now, companies that failed to challenge or more carefully scrutinize these actions do also bear some responsibility. And look, over the years, I've been customers of all three companies present here today, AT&T and Verizon, and more recently, T-Mobile. This is a big issue. It's a serious issue where fundamental rights are at stake. And that's why I think we need to focus our efforts on the fact that things like this happen. Remember what happened with the Church Committee back in the 70s. It went through and reviewed how these kinds of abuses have taken place over the years. One of the findings that they reached was that in every presidential administration since Woodrow Wilson, up until the time of the church hearings in the 1970s, in every one of those administrations, some portion or portions of our intelligence gathering and law enforcement apparatus had been weaponized for political espionage against the president's perceived political enemies. Every single one of them. That's why this unleashed a raft of reforms, many of which remain in place to this day, but some of which apparently need updating to reflect changes in technology and technique, and perhaps we've gotten rusty. One of those pieces of legislation that I think we need to focus on involves something with bipartisan support, something that Senator Coons and I reintroduced recently, called the Non-Disclosure Fairness Act. And it would mandate meaningful judicial review to ensure that non-disclosure orders meet certain constitutional standards, requiring courts to issue written findings justifying the lawfulness of those orders. Now, this bill would apply not just to senators, not just to members of Congress, but it would protect the rights of all Americans who might be subject to such a non-disclosure order. Senators Blackburn and Cruz have joined as co-sponsored, and I hope all senators will as well, regardless of which party they belong to. This should be important to everyone. We should also be concerned about other areas where these abuses might be taking place. There are too many to name here, but one of them that is particularly relevant in the coming weeks involves Section 702 of the Foreign Intelligence Surveillance Act. As the name implies, this is supposed to be about getting communications of foreign adversaries, not American citizens. But as with what we're covering here, these requests from telecommunications companies backed by a non-disclosure order, so too with FISA 702. Somebody can, metaphorically speaking, be run over without ever knowing what happened, without ever knowing that they were victimized. Perhaps ever, perhaps not for months or years after the fact, after the damage has been done, after their privacy has been invaded, after their constitutional rights have been trampled. That's why Congress has no business reauthorizing FISA 702, as it's being called upon to do in the coming months, without a warrant requirement applicable to inquiries involving U.S. citizens and other U.S. persons. The Fourth Amendment matters. And political warfare, lawfare, is bad. We shouldn't weaponize these things, and we should put in place protections to make sure that the Fourth Amendment's protections, fought for many centuries in this country, and that have a tradition that goes back centuries before we were even a country in England. These things matter. We have to make sure that they are not rendered dead letter. And I can tell you we're heading dangerously in that direction now. What we're discussing at this hearing, I fear, is only the tip of the iceberg. We must fix it. Thank you.